for violations of the Uniform Code of Military Justice. That is mainly soldiers who served in Iraq, mainly soldiers who were complicit in the Abu Ghraib scandal in Iraq. Some of them were tried before court-martials, before military court, and they were sentenced to sentences from few months to up to 10, 15 years maximum. That was the leader of the soldiers who did the Abu Ghraib scandal. But those are very small number of cases. That's number one. Number two, none of them was actually tried or prosecuted for acts of torture. In the United States Code, you don't have the crime of torture as many other countries have incorporated it into domestic law. You have the torture statute that would criminalize acts of torture committed overseas, but is not. It is limited with time limitation. So if an act of torture happened in a particular country at a particular time, you have of 8 to 10 years of time limitation. That afterwards, you cannot prosecute people unless the act of torture resulted in death. So you have a small window of time to do this kinds of investigations, and if you find credible evidence, to bring people to justice. Now, beside those handful cases of soldiers who were held accountable, we know that the two kinds of investigation, or three kinds of investigations are going on right now. One investigation is not actually a criminal investigation. It was a disciplinary investigation by the Justice Department of the Office of Ethical Responsibility that looked at the violations of the Code of Ethics by the Justice Department lawyers like John Yoo or and Judge Biden, who gave the Bush administration the legal authorization to use acts of torture. This investigation was completed. It submitted the report to the Attorney General. The Attorney General in the United States has not declassified or released the report yet, but our understanding that his recent action of opening a preliminary investigation into the acts of torture was based on this report, because the report of the Office of Ethical Responsibility recommended to reopen the cases of torture where CIA agents have actually committed acts that are a violation of US law. So the current status is that the Attorney General has asked a prosecutor from the Justice Department to look at only specific and small number of cases where there was violations or there was a breach of the guidelines that were set by the Justice Department. It is not a comprehensive investigation. It is not as independent as we think it should be. We had called for appointing a special counsel or a special independent prosecutor because the Justice Department itself was involved in the torture regime, if you like. And so that is the second kind of investigation. The third kind of investigation started in the Bush administration when there was news report about the destruction of videotapes by the CIA which documented the torture of detainees. And there were 92 videotapes that were destroyed, and the former Attorney General under the Bush administration ordered to investigate the destruction of the videotapes, did not order the investigation of the torture itself. That was obviously quite astonishing. But this investigation is still an open one. We don't know what the results is. Very much under wrapped. There are no leaks, and the same prosecutor who was appointed to investigate the destruction of the CIA videotapes is the same one who is looking at those small number of cases that are being investigated right now. The last point I want to make, and then I do want to hear the other panelists and obviously hear your questions, is that this is not only a U.S. problem. It is mainly a United States responsibility to hold those who committed acts of torture and other cruel, inhumane, or degrading treatment responsible for their acts. And it will be a major test for the United States to do that. But I think it is also a responsibility of other countries that have close relationship and alliances with the United States, have also played a role in providing assistance of any kind, and have also been and they ratified both the Convention Against Torture, the Geneva Conventions, and the International Criminal Criminal Tribunal or Criminal Court, the Rome Statute of 1998. And I think Poland will certainly fall under this category. And I'm more than happy to discuss your views on what do you think the role that should happen in for Poland as a government, as a sovereign government, and looking at what happened in its own backyard, providing assistance to the CIA, to torture and to waterboard for 183 times individual like Khalid Sheikh Mohammed, who was held here. And to what extent this kind of investigation will send the right message to the people on not only in Poland or in the United States. It's a message, I think, that resonates around the world. That we I think come to realize that torture is a prohibition, is prohibited at all times, at all circumstances. And if we don't investigate and prosecute those who order torture, no matter what the circumstances are, I think we will go back 30 or 40 years, and that's, I think, a result that no one wants to have. Thank you.
Thank you very much. Proszę Państwa, ja myślę, że jest wiele szczegółowych kwestii, które poruszył Jamil Dakwar w swoim wystąpieniu, o których moglibyśmy dyskutować. Myślę, że jako takie krótkie podsumowanie tego, co powiedział, może posłużyć cytat z artykułu Davida Cola pod tytułem Memoranda legalizujące tortury, oskarżenie przeciwko prawnikom, który powiedział, że bez pociągnięcia do odpowiedzialności osób, które uczyniły z tortur, nieludzkiego i poniżającego traktowania oficjalną politykę USA, zaangażowanie Stanów Zjednoczonych w rządy prawa będzie tylko nic nieznaczącym frazesem. Myślę, że to też jest przesłanie, które Jamil w swojej wypowiedzi formułował. Ciekawym, myślę, problemem, do którego chciałabym ja ze swojej strony, żeby panowie, którzy będą zabierali głos, się odnieśli, jest problem właśnie tego, że prokurator generalny Eric Holder ogłosił, że agenci CIA, którzy brali udział w przesłuchaniach, będą z wykorzystaniem tych specjalnych metod przesłuchań, nie będą karani, o ile nie wykroczyli poza te wytyczne zawarte w memorandach przygotowanych przez Ministerstwo Sprawiedliwości, co oznacza, że nie będą pociągani do odpowiedzialności prawnicy, którzy w tych memorandach uznawali tortury za tortury, bo tak choćby Międzynarodowy Czerwony Krzyż o tych czynnościach się wypowiada. Nie będą oni, tylko ci będą pociągani do odpowiedzialności, tylko ci, którzy przekroczyli te wytyczne z memorandów. Do tego chciałabym, żeby się panowie odnieśli w swoich wypowiedziach, no i odnieśli się, żeby się panowie również odnieśli się do kontekstu polskiego. Ja myślę, że warto przypomnieć krótko, co wiemy, jeśli chodzi o Polskę i te oskarżenia dotyczące istnienia tutaj tajnego więzienia CIA. Wiemy dość już dużo i z dużym prawdopodobieństwem wiemy, że ta baza w Polsce istniała i byli tutaj przetrzymywani więźniowie, przede wszystkim dzięki drugiemu raportowi przygotowanemu przez Dita Martiego, specjalnego sprawozdawcę Rady Europy. Tam znajduje się dość dużo już szczegółów popartych wieloma dowodami.